Reading constitutional law, starting with part 1, the federal government, the judicial power. Article 3 is subpart A. Federal judicial power extends to cases involving interpretation of the Constitution and foreign citizens and citizens of diverse citizenship. I'm sorry, that's totally wrong. I just put 2 lines together. 1 is interpretation, 2 is disputes. 1 reads as follows: under the federal judicial power extends to cases involving interpretation of the Constitution, federal laws, treaties, and admiralty and maritime laws, and to disputes between states and foreign citizens and citizens of diverse citizenship. Subpart B in the judicial power is the power of judicial review. The Supreme Court may review the constitutionality of acts of other branches of the federal government. It may also review state acts pursuant to the Supremacy Clause. Federal courts, subpart C. Only Article 3 courts established by the Congress pursuant to Article 3 are subject to this outline. Congress has power to delineate the original and appellate jurisdiction of these courts, but is bound by the standards set forth in Article 3 as to the subject matter and party jurisdiction and the requirement of a case or controversy. Congress can also create courts under Article 1, example, tax courts. Judges in those courts do not have life tenure as do Article 3 judges, and Congress may not assign to Article 1 courts jurisdiction over cases that have traditionally been tried in Article 3 courts. Subpart D, jurisdiction of the Supreme Court. 1, original jurisdiction. 2 will be appellate jurisdiction. Perhaps that's it. No, there's a P. Yes. There's original jurisdiction first. The Supreme Court has original jurisdiction in all cases involving ambassadors, public ministers, consuls, and those in which a state is a party. The Congress has given concurrent jurisdiction to lower federal courts in all cases except those between states. Appellate jurisdiction. Supreme Court has appellate jurisdiction in all cases to which federal power extends, subject to congressional exceptions and regulation. Cases can come to the court by one of 2 ways: writ of certiorari. Most cases, the Supreme Court has complete discretion to hear cases that come to it by certiorari. The cases that come by certiorari are cases from state courts where the constitutionality of the federal statute, federal treaty, or state statute is an issue, or 2, the state statute allegedly violates federal law. 2, all cases from federal courts of appeals. Appeal, rare cases. The Supreme Court must hear cases that come to it by appeal. These cases are confined to decisions by 3-judge federal district court panels and that grant or deny injunctive relief. The constitutional, so now in subpart E, constitutional and self-imposed limitations on exercise of the federal jurisdiction. Whether a case is justiciable, for example, the federal court may address A depends on whether there is a case or controversy. In addition to the case or controversy requirement, there is other limitations on federal court jurisdiction. No advisory opinions is one. There must be specific present harm or threat of specific future harm. Federal courts can hear actions for declaratory relief if there is an actual dispute between parties having adverse legal interess. Complainants must show that they have engaged in or wish to engage in specific conduct and that the alleged action poses a real and immediate danger to their interests. However, the federal courts will not determine the constitutionality of a statute if it has never been enforced and there is no real fear that it ever will be. Ripeness. 2. Under the justiciability doctrines. To avoid issuing advisory opinions, courts wait until policies have been formalized and can be felt in concrete ways. When considering a question of ripeness, the federal court considers two main factors: the fitness of the issues for judicial decision, and 2, the hardship to the parties of withholding court consideration. Fitness for judicial decision. Generally, an issue is not fit for judicial decision if it relies on uncertain or contingent future events that may not occur as anticipated. Hardship to the parties. A court will find that an action is right for review if a party would have to risk substantial hardship to provoke enforcement of law. Mootness. A real controversy must exist at all stages of review. If the matter has already been resolved, the case will be dismissed as moot. Exception. Future events that may not occur as anticipated. Mootness. A real controversy must exist in all stages of review if the matter has already been resolved. A. Exception. Controversies capable of repetition but evading review are not moot. Examples: issues concerning events of short duration, for example, abortion, or a defendant who voluntarily stops the offending practice but is free to resume. Class actions. A class representative may continue to pursue a class action after the representative's controversy has become moot if claims of other class members are still viable. Ripeness bars consideration of claims before they have been developed. Mootness bars their consideration after they have been resolved. Standing. A person may have a concrete stake in the outcome of the case at all stages of litigation, including an appeal. Components. Injury in fact. To have standing, a person must be able to assert an injury in fact, which requires both particularized injury, an injury that affects the plaintiff in a personal and individual way, and 2, a concrete injury, one that exists in fact. It is not enough to show merely that a federal statute or constitutional provision has been violated and that we all suffer when that happens. The injury need not be economic. Causation. 2, under components of standing, there must be a causal connection between the injury and the conduct complained of. And redressability. A decision in the litigant's favor must be capable of eliminating his grievance. Common standing issues. 1. Congressional conferral of standing. Congress has no power to eliminate the case or controversy requirement and thus cannot grant standing to someone not having an injury. However, state statutes may create new interests, injury to which may be sufficient for standing. Standing to enforce government statutes. Plaintiff may have standing to enforce a federal statute if she is within the zone of interest Congress was meant to protect. Standing to assert the rights of others. Generally, one cannot assert the constitutional rights of others to obtain standing, but a claimant with standing in her own right may also assert the rights of a third party. If 1, it is difficult for the third party to assert their own rights, an association may attack a law requiring disclosure of membership lists because members cannot attack the law without disclosing their identities, or a special relationship exists between the claimant and the third party. For example, a doctor can assert a patient's rights in challenging an abortion restriction. Standing of organizations. An organization has standing if there is an injury in fact to members that gives them a right to sue on their own behalf. 2, the injury is related to the organization's purpose. And 3, the individual member participation in the lawsuit is not required. That's for standing of organizations. Injury in fact to the members that gives them a right to sue on their own behalf. The injury is related to the organization's purpose, and the individual member participation in the lawsuit is not required. No citizenship standing. People have no standing merely as citizens to claim that government action violates federal law or the Constitution. The injury is too generalized. A person may have standing to allege that federal action violates the 10th Amendment by interfering with powers reserved to the states as long as the person has a redressable injury in fact. That's no citizenship standing. Taxpayer standing requisites. A taxpayer has standing to litigate her tax bill, but a taxpayer generally has no standing to challenge government expenditures because the taxpayer's interest is too remote. Similarly, a taxpayer, as such, has no standing to challenge tax credits. Exception. Suits attacking congressional pending measures on First Amendment Establishment Clause grounds. Example, constitutionally approved federal expenditures to aid parochial schools. Exam tip. For a taxpayer to have standing, I feel like I didn't read a conclusion there. That's an exception. So that's an exception to taxpayer standing requisites. Oh, beautiful. For a taxpayer to have standing, Congress's spending power must be involved. Thus, for example, there is no standing to challenge federal government grants of surplus property to religious groups or expenditures of general executive branch funds. I don't know why this is in the judicial section, talking about Congress and the executive branch, whatever. I'm just going to get to the legislative power and go to sleep. I am tired. Adequate and independent state grounds. The Supreme Court will not exercise jurisdiction if the state court judgment is based on adequate and independent state law grounds. Even if federal issues are involved, state law grounds are adequate if they are fully dispositive of the case. They are independent if the decision is not based on federal case interpretations of identical federal provisions. When the state court has not clearly indicated that its decision rests on state law, the Supreme Court may hear the case. Abstention. Unsettled question of state law. A federal court will temporarily abstain from resolving a constitutional claim when the disposition rests on an unsettled question of state law. Pending state proceedings. Federal courts will not enjoin pending state criminal proceedings, and in some cases, pending state administrative or civil proceedings involving an important state interest, except in cases of proven harassment or prosecutions taken in bad faith. Political questions. Political questions will not be decided. These are issues constitutionally committed to another branch of government or inherently incapable of judicial resolution. Examples of political questions. Challenges based on the Republican form of government clause of the Article 4, challenges to congressional procedures for ratifying constitutional amendments, the president's conduct of foreign policy, and partisan legislative apportionment gerrymandering are political questions. Compare non-political. It doesn't say if it's federal or state, but I'm assuming that's probably federal. Legislative apportionment. Compare non-political questions. arbitrary exclusion of the congressional delegation or production of presidential papers and communication are not political questions. 11th Amendment limits on federal courts. The 11th Amendment prohibits federal courts from hearing a private parties or foreign government's claims against a state government. What is barred? The prohibition extends to actions in which the state is named as a party or in which the state will have to pay retroactive damages. Similarly, the Supreme Court has held that the doctrine of sovereign immunity bars suits against state government and state court, even on federal claims, unless a defendant state consent. What is not barred? The prohibition does not extend to actions against local governments, actions by the United States or other states, or proceedings in federal bankruptcy courts. Exceptions. Certain actions against state officers. The following actions can be brought against state officers in federal court despite the 11th Amendment. That's an I. Actions to enjoin an officer from future conduct that violates the Constitution or federal law, even if this will require prospective payment from the state. And 2, actions for damage against an officer personally. Right, state officers, got it. Congress removes immunity. Congress may remove 11th Amendment immunity as actions created under the 14th Amendment, but it must be unmistakably clear that Congress intended to remove the immunity. So I'm only 16 minutes into this break. I should probably hit all of the first 3 articles of the Constitution. But I can see legislation is pretty big. It's like 6 pages, and I've only read 5. Shall I continue? Legislative power. The federal government has limited powers. Every exercise of federal power must be traced to the Constitution. Enumerated and implied powers. Congress can exercise those powers enumerated in the Constitution plus all auxiliary powers, necessary and proper to carry out all powers vested in the federal government. Necessary and proper power. Congress has the power to make all laws necessary and proper, appropriate for executing any power granted to any branch of the federal government. Exam tip: the necessary and proper clause standing alone cannot support federal law and must work in conjunction with other federal power. Thus, an answer choice that states that the law is supported by the necessary and proper clause or is valid under Congress's power to enact legislation necessary and proper will be incorrect unless another federal power is linked to it in the question. Taxing power. Congress has the power to tax, and most taxes will be upheld if they bear some reasonable relationship to review production or if Congress has the power to regulate the activity taxed. Whether something is a tax as opposed to regulation depends largely on its function. For example, does it seek to bring money into federal coffers rather than on a label given by Congress? Spending power. Congress may spend to provide provide for the common defense and general welfare. Spending may be for any public purpose. Exam tip: the federal government can tax and spend for the general welfare. It cannot directly legislate for it. Thus, non-spending regulations cannot be supported by the general welfare clause. Also recall that although the power to spend for the general welfare is broad, any public purpose, it is still limited by the Bill of Rights and other constitutional provisions. Commerce power. Congress has the power to regulate all foreign and interstate commerce. To be within Congress's power under the Commerce Clause of federal law regulating interstate commerce must either regulate the channels of interstate commerce, regulate the instrumentalities of interstate commerce, and persons and things in interstate commerce, or regulate activities that have a substantial effect on interstate commerce. Channels, instrumentalities, activities. I don't like activities. I'd really love to see them spell out here. Talking manufacturing, talking distribution, one other thing. Production? No, that's manufacturing. Intrastate activity. When Congress attempts to regulate intrastate activity under the third prong above, the court will uphold the regulation if it is of economic or commercial activity. For example, growing weed or medicinal marijuana, even for personal consumption, and the court can conceive of a rational basis on which Congress would conclude that activity in aggregate substantially affects interstate commerce. However, if the regulated intrastate activity is non-commercial and non-economic, for example, possessing a gun in a school zone or gender-motivated violence, the court generally will not aggregate the effects, and the regulation will be upheld only if Congress can show a direct substantial economic effect on interstate commerce, which it generally will not be able to do. Activity versus inactivity is like a subpart of this intrastate activity. So the Commerce Clause gives Congress powers only to regulate existing commercial activity. It does not give Congress power to compel activity. I'd like to see that. Perfect. Or at least I'd like to know what seminal case that came from. War and related powers. The Constitution gives Congress power to declare war, raise and support armies, and provide for and maintain a navy. Economic regulation. The regulation during war and in the post-war period to remedy wartime disruptions has been upheld. Military courts and tribunals. Congress is authorized to make rules for the government and regulation of armed forces. Judicial review. Regular federal or state courts have no general power to review court-martial proceedings. Enemy civilians and soldiers. Enemy civilians and soldiers may be tried by military courts. However, Congress has no power to deny habeas corpus review to all aliens detained as enemy combatants, absent a meaningful substitute for habeas corpus review. Congress has no power to deny habeas corpus review to all aliens detained as enemy combatants, absent a meaningful substitute for habeas corpus review. American soldiers. Military courts have jurisdiction over all offenses committed by persons who are members of the armed forces both at the time of the offense and when charged. American civilians may be tried by military courts under martial law only if actual warfare forces the federal courts to shut down. Investigatory power. The power of Congress to investigate is implied. Investigation may be expressly or impliedly authorized by the appropriate congressional house. Property power. Congress has the power to dispose of and make rules for territories and other properties of the United States. While there is no express limitation on Congress's power to dispose of property, federal takings, eminent jurisdiction must be for the purpose of effectuating enumerated power unless some other provision of the Constitution. No federal police power. Congress has no general police power. However, Congress has police power type powers over the District of Columbia, federal lands, military bases, and Indian reservations based on its power over the Capitol and its property power. I have no power over Capitol. If an answer choice attempts to support federal action on the basis of the police power, for example, Congress can constitutionally act under the police power, or the action is valid under the federal police power. See whether the facts state that the action pertains to the District of Columbia or other federal possessions. If not, it is the wrong choice. Bankruptcy power. Congress's power to establish uniform rules for bankruptcy is not exclusive. States may legislate in the field as long as their laws do not conflict with federal law. Postal power. The postal power is exclusive. Under the postal power, Congress may validly classify and place reasonable restrictions on the use of the mails, but may not deprive any citizen or group of citizens of the general mail privilege. Power over citizenship. Congress may establish uniform rules of naturalization. This gives Congress plenary power over aliens. Exclusion of aliens. Aliens have no right to enter the United States and can be refused entry summarily because of their political beliefs. However, resident aliens are entitled to notice and a hearing before they can be deported. Naturalization and denaturalization. Congress has exclusive power over naturalization and denaturalization. However, Congress may not take away the citizenship of a citizen, native born, or naturalized without his consent. What if he violates a law of moral turpitude? Admiralty power. Congress's admiralty power is plenary. Hey Siri, what's the definition of plenary? As expected, it would be unqualified and absolute as an adjective. And so I read that again and have just a hard time processing this. Congress's admiralty power is plenary and exclusive, unless Congress leaves maritime matters to state jurisdiction. So what about the executive branch? I just don't understand that. Power to coin money and fix weights and measures. Congress has the power to coin money and fix standards for weights and measures. Patent copyright power. Congress has the power to control the issuance of patents, and copyrights. Delegation of legislative power. Legislative power may generally be delegated to the executive or judicial branch as long as intelligible standards are set and the power is not uniquely confined in the Congress. For example, powers to declare war and impeach. Note, Congress may not appoint members of a body with administrative or enforcement powers. Exam tip, although you should know that a valid delegation of legislative powers requires intelligible standards for the delegate to follow, see above. In applying that, the rule almost anything will pass as an intelligible standard, and thus no legislative delegation has been invalidated since 1936. So there's this crazy chart. I don't know what it's doing here. I'll read it at the end of this section because it's only subpart C, subpart D. Subpart C, speech or debate clause, immunity for federal legislators, conduct that occurs in the regular course of the federal legislative process and the motivation behind the conduct are immune from prosecution. Immunity does not cover bribes, speeches outside of Congress, or the republication of a press release or newsletter of a defamatory statement originally made in Congress. Separation of powers, a requirement of bicameralism and presentment. Oh, I haven't heard this in a while. To pass a law, Congress must use bicameralism, passage of a bill by both houses of Congress, followed by presentment to the president for signature or veto. Attempts by Congress to create laws or control the enforcement of laws without bicameralism and presentment are involved. So before going to the executive power, I'm looking at a chart on page 9, sources of congressional power, and government actions on the left and source of powers on the right. So they relate to one another, and there's 8 government actions. So Congress enacts divorce laws for the District of Columbia. The source of the power is general government police power for D.C., as well as military bases and federal lands. Congress pays for highways. Spending power in Commerce Clause is the source of that power. Federal income tax, the 16th Amendment taxing power. Congress conditions aid to states for medical programs on state funding of AIDS research, and that comes from the spending power. Congress adopts a tax to regulate banknotes rather than to raise revenue is the source of power. Is the power to coin money. From the property power is Congress is power to prohibit hunting on federal lands. From the Commerce Clause arises Congress's bars racial discrimination at places of public accommodation. From the Commerce Clause arises that Congress requires all employers, including state governments, to comply with federal minimum wage overtime provisions. The amendments to the Constitution may also be a source of power. For example, the 13th Amendment gives Congress power to outlaw badges of slavery. Thus, Congress may require a private seller to sell land to blacks as well as whites. So we'll track on through the executive power. And afterwards, we'll get to the federalism concept. So only 4 pages here. Domestic powers is part A. Power over external affairs is part B. And executive privilege and immunity is part C. So within domestic powers is 1, appointment and removal. A, appointment powers. The executive appoints all ambassadors, other public ministers and consuls, justices of the Supreme Court, and all other officers of the United States whose appointments are not otherwise provided for. With advice and consent of the Senate, Congress, however, may vest the appointment of inferior officers in the president alone, the courts, or the heads of departments. Congress itself may not appoint members of a body with administrative or enforcement powers. Okay, it's just like the same thing I read before. Removal of appointees by president. The president can remove high-level, purely executive officers, such as his cabinet members, at will, without any interference by Congress. However, Congress may provide statutory limitations, for example, removal only for a good cause on the president's power to remove all other executive appointees by Congress. Congress may remove executive officers only through the impeachment process. Now, for pardon power, the president may grant pardons for all federal offenses. Now, remember that's federal offenses only, but not for impeachment or civil contempt. The pardon power cannot be limited by Congress. It says nothing about state laws, like state criminal laws. Veto power. If the president disapproves, vetoes, an act of Congress, the act may still become law if the veto is overridden by a 2/3 vote of each house. Pocket veto. The president has 10 days to exercise the veto power. If he fails to act within that time, the bill is automatically vetoed. If Congress is not in session, the Congress is in session, the bill becomes law. Line item veto unconstitutional. The veto power allows the president only to approve or reject the veto in toto. He cannot cancel part through a line item veto or approve other parts. Power as chief executive. The president's powers over internal affairs are unsettled. Clearly, the president has some power to direct subordinate executive officers, and there is a long history of presidents issuing executive orders. Perhaps the best guide is as follows. 1, 2, and 3. 1, if the president acts with the express or implied authority of Congress, his authority is at its maximum and his actions are likely valid. 2, if the president acts where Congress is silent, his action will be upheld unless it usurps the power of another governmental breach or prevents another branch from carrying out its task. And 3rd, if the president acts against the express will of Congress, he has little authority and his action likely is invalid. For example, the president has no power to refuse to spend appropriated funds when Congress has expressly mandated that they do so. No power to impound, and the take care clause. It follows from the above that the president has no power to refuse to spend appropriated funds when Congress has expressly mandated they are spent. Some authorities' bases result in Article 2, Section 3, Clause 4, the take care clause, which provides that the president shall take care that the laws be faithfully executed. Power over external affairs. War. Foreign relations. Treaty power. The president has no power to declare war, but may act militarily in actual hostilities against the United States without a congressional declaration of war. However, Congress, under its power to enact a military appropriation every 2 years, may limit the president. Foreign relations. A president has paramount power to represent the United States in day-to-day foreign relations. Treaty power. The president has the power to enter into treaties with the consent of 2/3 of the Senate. Supreme law. Like other federal law, treaties are the supreme law of the land if they are self-executing, for example, effective without any implementation by Congress. State laws that conflict with the state executing treaty are invalid. Note that the president generally does not have any independent power to issue a memorandum ordering compliance with a treaty that is not self-executing. What are they calling self-executing? Is that different? Yeah. Oh, yeah, it's just effective without any implementation of Congress. Conflict with federal laws. The conflict between a congressional act and a valid treaty is resolved by order of adoption. The last in time prevails. Conflict without Constitution. Treaties are not co-equal with the Constitution. A treaty may be inconsistent with the Constitution. Treaties are subject to constitutional limits. A treaty may not be inconsistent with the Constitution. I probably read that wrong because I thought about it wrong. Thus, no treaty or executive agreement can confer on Congress authority to act in a manner inconsistent with any specific provision of the Constitution. Executive agreements. Executive agreements are signed by the president and the head of a foreign country. They can be used for any purpose that treaties can be used for. They do not require the consent of the Senate. Conflict with state laws. If the state law conflicts with an executive agreement, the agreement prevails. Conflict with federal laws. If an executive agreement conflicts with federal law, the federal law prevails over the agreement. And there's like this hierarchy of the Constitution, which prevails over treaties and federal statutes. In a conflict between these two, the last in time prevails. And that all prevails over executive agreements, which prevails over state law. C, executive privilege immunity. For the privilege, president has the privilege to keep certain communications secret. National security secrets are given their deference by court. Exception in criminal proceedings, presidential communiques will be available to the prosecution where a need for such information is demonstrated, which is like a criminal proceedings. Executive immunity. The president has absolute immunity from civil damages based on any action he took within his official responsibilities, but there's no immunity for acts that allegedly occurred before taking office. If presidential aides have exercised discretionary authority in a sensitive area, they may share the immunity for suits brought concerning that area. Like, one important thing I believe is that all of these actions can be brought after they're no longer holding that post, but I'm not guessing. Impeachment. The president, vice president, and civil officers of the United States are subject to impeachment. The bringing of charges. Grounds include treason, bribery, high crimes, and misdemeanors. A majority vote in the House is necessary to invoke the charges of impeachment, and a 2/3 vote in the Senate is necessary to convict and remove the office. So we'll get into federalism next, but not